there are 8 Republicans in total in the state of Iowa who are now trying to dictate what the state of Iowa voters have the choice to vote for. The 6 objectors and 2 panel members. The state, the big kid on the block, had all the power from the get-go. On June 5th, the objectors had all of the information to file the objections. They waited until August 5th to do so. The Secretary of State, who ultimately set the hearing, set it for August 28th, hoping that we, the small kid on the block, are not going to be able to file the petition, get the injunction, and get as far as we did. Iowa can do better than that. We are asking the court to overrule the reverse the decision of the objectors and allow our candidates to be on the ballot. Thank you.
Thank you, Judge. May it please the court, my name is Jen DeCook, and I represent the petitioner Marco Battaglia. He's the duly nominated Libertarian Party candidate for Iowa's 3rd Congressional District, sitting here in Des Moines. Judge Hubbard, you focused on 2 issues when you ordered the temporary injunction in this case. Your first was that the objection is to the timing between the party caucuses and the county conventions. As we've pled in our brief, it's 181 minutes. Finished caucuses at 9 p.m., went into convention as opposed to waiting until midnight. So is that appropriate when we look at the language of Iowa Code Section 43.94 in juxtaposition with all 3 of the petitioner's substantive rights that will be addressed later by my colleague, Mr. Hurd? And then your second issue, Judge, was whether such objections are even properly brought before the respondent state objections panel, or whether that's outside the scope of their authority under Code Section 43.24, which we posit that it is. The first issue, Judge, I think can be addressed by referring to the timeline that we just heard in the opening arguments. Mr. Osterman knew on June 5th that his inquiries to state auditors showed that there was a procedural question about the way that the caucuses and conventions had taken place. At that point, the appropriate remedy would have been a technical infraction notice under Code Section 39A.6. As Mr. Osterman helpfully points out in his objection, the deadline to hold those conventions was June 14th. However, Mr. Osterman sat on this information, did nothing with it until he filed his objections in August. And then our Secretary of State did not hold a hearing on this matter until the 28th of this month, 3 weeks prior to the deadline to certify these ballots. This is obstructionism and voter suppression, Judge. There's no other question here. So when we walk the court through what we believe should be the analysis for your ruling, the most conservative approach is to find that these objectors lack standing. The 2 parties in our case, the parties that are objecting in the cases involving Mr. Gluba and Mr. Aldrich, none of them have filed certifications to this court that they are registered voters. None of them have filed certifications to this court of where they live. And most importantly, none of them have shown us how they were injured. When we have standing, we have 2 issues. We need, first, we need an injury in fact. And second, we need a right that is individual, a personal injury to these particular... For a second,
yes. Doesn't the statutory scheme essentially have its own standing requirement, for lack of a better term, that may not be the right term, by allowing anyone who could have voted for any of these candidates in the district to object?
Judge, I would say that you are absolutely correct as it comes to 43.24 objections before this panel. But the objections we're dealing with today are outside the purview of this panel. This panel is supposed to look at certificates of nomination and petitions for nomination. We are not talking about the greater scheme of voting rights in Iowa under the entirety of Chapter 43. Absolutely. Any registered voter has standing to object to those, but that's not what we're looking at here today.
So who would have standing, in your opinion?
Certainly, Judge. Well, I think you have two different sets of people. You would have a libertarian who felt that this particular failure by their party was inappropriate, and they could object to the fact that they perhaps did not have notice between the caucuses being held and then 181 minutes later, the convention being held. But we could also look at people who have an injury, in fact, who are also on this ballot. So perhaps another candidate who would believe that a libertarian candidate, or any party candidate for that matter, who appeared on the ballot, could potentially pull votes from them. They would have standing to say, this is not appropriate, this is outside the, not only outside the jurisdiction of this panel, but also they would have standing to bring the injury to the attention of the court as someone with an injury in fact. We are looking here at the very definition of generalized injury that's essentially suffered by the public if it is suffered at all.
Isn't any registered voter's vote affected and potentially injured by virtue of having someone on a ballot who shouldn't be there?
Well, Judge, I would argue that there's not a question here of whether these individuals should or should not be on this ballot. The question is, were they nominated by their party at convention? And the answer is resoundingly yes. We filed documents that show the convention was held, the nominations were certified, and as far as the Libertarian Party is concerned, these individuals are properly on the ballot. And it's the Libertarian Party's governance of the caucus and convention process that is what these interveners, these objectors, truly seek to harm today. What they're trying to do is say, if you don't do it, if you don't follow the minutia, if you don't make sure that all your T's and I's are crossed and dotted, then we're going to take you off the ballot. If you don't comply, then your substantive rights are destroyed. Make no mistake, that's what's being asked for today. We're starting with the Libertarians, then we'll have a field day with the Democrats, and then if there's any other parties that come to challenge these particular objectors, this decision will give them grounds. This decision will be the precedent that allows any voter, any person with an axe to grind, anybody who's worried about pulling votes, who isn't willing to stand up as a candidate and complain about it themselves. They're going to come here.
What's so wrong with dotting I's and crossing T's?
I don't think...
Is a strict compliance required of this kind of law?
Well, Judge, I don't think that the Supreme Court has told us, the federal Supreme Court has told us that strict compliance is required. When it interferes with the substantive due process rights of voters, and by extension, the people that voters nominate to be on their ballots. You know, we've addressed this in our pleadings, Judge. I would point you to both our petition and then also the reply brief, where we talk about the substantive due rights that are being negatively impacted here under the court's decision in Ex Rel La Follette, the state, or the, pardon me, I'll get you the citation. Democratic Party of the United States v. Wisconsin, Ex Rel La Follette, 450 U.S. 107 at page 121. So any interference with the freedom of a party is simultaneously an interference with the freedom of its adherents. And then the La Follette decision goes on to discuss the fact that suppressing candidates' appearance on a ballot is the same as suppressing a vote. It's exactly the same principle, and that's how the Iowa Supreme Court and that is how the federal Supreme Court have looked at it, Judge. This is worthy of the greatest protection. Now, if there is a real question about T's being crossed and I's being dotted, it should have been raised through 39A.6. There's no question here, Judge, that there is a remedy, but objecting to this panel is not the remedy. Which brings me to my second point, Judge. This panel is entirely outside of its authority. This panel's authority is limited to whether nomination petitions have the right number of signatures and whether those signatures are authentic and authenticized. And it also governs the nominating petitions. We're not here today to say that this state panel has the authority to poke its nose into every party's county caucus and convention and say, you did this right, you did this wrong. They're not authorized to do that by the legislature. We had an entire overhaul of our voting rights statute here less than 3 years ago. Nowhere was this panel empowered to make the kind of decision that it made on the 28th, Judge. So I would also like to point out that the caucuses are not a state activity, Judge. They are not paid for, they're not administered by the state. This gives the state actually less of an interest and fully brings the caucus and convention procedure and processes within the purview of the Libertarian Party and the Libertarian voters. So certainly there is a state interest in making sure that our elections are full and fair and that everyone has an opportunity to participate in their county caucus convention. On a practical matter, I would say that given that we are looking at the Libertarian Party with 2% of the vote, most of the folks who are Libertarians did show up. So again, we have that injury in fact problem. We don't have an injury in fact here, certainly not by the objector interveners. And I have not seen any Libertarian voter who's come forward to say that they were disenfranchised by the caucus or the convention process. And that's where our substantive due process arguments come in, and I'll let Mr. Hurd make those unless you have any other questions, Judge.
No, thank you.
Thank you.
Mr. Hurd.
May it please the court, counsel. The substantive rights that have been violated, that were violated when these three Libertarian candidates were removed from the ballot are substantial. It has been long held.
I'm going to ask you to remain seated so you can use the microphone to full advantage.
Thank you, Your Honor. It has been long held that voting is a fundamental right above all others. It is also a fundamental right to have the freedom to associate with members of your own party and to collectively organize for the benefit of a greater good or a collective good. It is also, that goes with the freedom of association, there is also the right to not associate with someone. These objectors do not associate with the Libertarian Party. The Libertarian Party does not associate with them. That is the right of the Libertarian Party as well as the standard bearers or the nominees for the party. When the respondents or the objection panel and the objectioners, they argue that the injury or harm that was caused to the candidates once they were removed is solely due to the caucuses and convention not having the correct timing. That's the incorrect harm or injury. The harm or injury we're talking about here today is using those statutes to remove them from the general election ballot through the objection panel process. That is, the state has yet to put forth an interest or what interest the state has in removing someone from a ballot due to a technical noncompliance. But on the flip side, on the candidate side, the harm to their substantive rights is substantial. Their voters no longer have the option to vote for them. They no longer, anyone that donated to their campaign monetarily, anyone that donated their time, labor, gone. And that all ties in with their freedom of association, their freedom to vote, and free speech as well. The standard that is to be used in challenges such as this is a balancing standard. It's not necessarily strict scrutiny or intermediate scrutiny, it's a balancing standard. In Smith v. Iowa District Court, the Iowa Supreme Court recently elaborated on that test, and it's the Anderson verdict test specifically. The court is to first consider the magnitude of the asserted injury, and on the petitioner side, it is quite substantial. It is their right of association, their right to appear on the ballot, their right to self-determination. And then on the court is to balance that against the state interest in their conduct or regulation.
What's the citation for that authority?
Yeah, for Smith v. Iowa District Court is 20. I don't have the Westlaw, but I have the appellate number. It's number 22-0401, page 24, and that is a 2024 case.
Go ahead.
So the court is supposed to balance the harm or injury on the side of the petitioners with the interest in the state regulating that conduct or the action taken by the state against the petitioners. In this case, the state may have a limited interest in regulating the time and manner of caucuses and conventions, but it is very minimal at best. It is merely a procedural technicality that has no substantive aspect of it. But that is not the actual conduct that's in question here. The state has to justify the interest they have in removing libertarian candidates from the ballot. That is to take away the vote or the option for Iowans to vote for these individuals and the right of the party, a major party here in Iowa, to nominate these individuals for the ballot at the general election. The state has not provided an interest, to my knowledge thus far, as to what is served by them removing these candidates from the ballot, but I would argue that there is none. There can be no interest in removing a major party's candidate that is duly nominated at a state convention from the ballot. And when you compare and weigh those two interests together, the right to free speech, to association, the right to vote, the right to be on the ballot, and this right of self-determination, compare that with the state's interest in, I don't know. The balance clearly weighs in favor of keeping these individuals on the ballot so that the voters of Iowa have an option other than the Republican or Democrat nominee in the 2024 general election.
Anything else, Mr. Hurd?
No, Your Honor.
Mr. Valencia.
Good morning, Your Honor, Counsel. Patrick Valencia on behalf of the State Objections Panel. Your Honor, the state of Iowa takes election integrity and transparency seriously. Open, transparent, and representative elections are important, and that's what Chapter 43 seeks to endeavor here. So I'll start here with the petitioner's first argument about what the proper remedy was in this case. They point to Chapter 39A, and they say that the panel should have issued a technical infraction and a written notice. The issue with that, which they have not confronted despite us raising it in our response and resistance, is that Chapter 39A authorizes the Secretary of State to issue such notice. It does not authorize the panel to do that action. Chapter 43.24 gives the panel the authority to hear these objections and determine whether a nomination petition, a certificate of nomination, or a candidate's eligibility is legally sufficient. Chapter 39A does not provide the remedy here, and it has no purpose in this case.
But is this the sort of technicality that would be governed by 39A and should have been the subject of a notice by the Secretary of State?
No, Your Honor. This is not just a technicality. This is the problem here that the petitioners and the Libertarian Party failed to do goes to the heart of our election integrity and transparency.
How so?
When we start with caucuses, at caucuses, delegates are elected to go to a county convention. County conventions do not exist without properly elected delegates. And then from the county convention elects delegates to go to a state convention. A state convention does not exist without properly elected delegates. Here, there were never any properly elected county convention delegates, and there's no county convention held to elect state convention delegates. Holding the county convention on the same day as the caucus goes against Chapter 43, which says that the delegate's term does not start until the next day. This goes to the heart of protecting our elections and making them transparent.
Well, again, how?
Your Honor, the Libertarian Party, when they took on the major party status, agreed to follow what they are calling technicalities. And here, requiring delegates' term to start the next day prevents overlapping delegate terms as a practical matter. Delegate terms last for 2 years. So you have to have the delegates' term start the next day to prevent overlapping competing delegates. It prevents a hostile situation where people at a caucus claim that there might have been cheating, there might have been improperly elected delegates. So by waiting until the next day to start, it gives people at the caucus that are claiming maybe that these delegates were improperly elected, it gives them time to make such challenge. Part of that responsibility as well, once these delegates are elected at the caucus, their names have to be reported to the auditor. This creates an audit trail so that the public knows who these delegates are, who was selected, and who is representing this party. Again, transparency and the representative nature of our elections is key, and this goes to the very heart of that. And so when you have 3 candidates submit a certificate of nomination that purports to be nominated at a county convention and then a state convention that did not have properly elected delegates, this means there is no authority, no one with actual authority issued this certificate. This certificate, as the interveners point out in their response last night, you could have a situation of dueling certificates. The point of 4324 is for a citizen who has the right to vote for the office that they want to that they're challenging. The point is to let them challenge the legal sufficiency of nomination petitions, certificates of nomination, and the candidate's eligibility. This is why 4324 doesn't just apply to getting someone's name on the primary ballot, because getting your name on the primary ballot has nothing to do with a certificate of nomination. That is the nomination petition. A certificate of nomination is the outcome of somebody that is nominated. It certifies that a candidate was nominated. This means that in 4324, the first sentence, 4324(1)A, says that objections to certificates of nomination are exactly what the state objections panel is meant to hear. And that is what they heard here. This is the type of objection that was allowed to be brought. It's the type of objection that the state objections panel hears. We submitted an example last night in our response briefing, Your Honor, of the 2004 objections panel that considered a general election a challenge to a candidate's name being on the general election ballot. It happens. That's what 4324 is meant for. Turning to the substantive rights argument, Your Honor, the Supreme Court has considered it, quote, too plain for argument that a state may require a primary or convention election process. The petitioners argue here that they're trying to protect their own right, but their right to be on the ballot derives from the Libertarian Party's right as a major party to be on the ballot. The state of Iowa authorized the Libertarian Party, after they met certain requirements, to become a major party. With that, great benefit came. They are allowed to have their names right there on the ballot with their party next to it. But also with that came the burden of following the rules. The Libertarian Party here did not follow the rules.
Every case that I've looked at so far that incorporates the too plain for argument phrase is common and decided frequently. In the next sentence, or within a sentence or two, it does acknowledge that there are limits to what the state can do. What are those limits?
Yes, Your Honor. One of the limits would be a discriminatory law that does not treat everybody equally. Here, all major parties are treated equally. All major parties are subject to the same rules. You could imagine a racially discriminatory situation. That obviously would not be allowed.
How about a more subtle, outer limit type limit, let's call it? It's maybe closer to the petitioner's concern.
It would have to be one that treats parties differently, Your Honor. Discriminatory regulation here. Regulations like this that are simply, you have to have a convention so that to ensure the state's interest in having your party's actually representative. That is not discriminatory. It doesn't treat anybody differently. It's quite reasonable, and it's the way party elections have gone on for our country's entire history.
But there are limits to what the state can do in relation to a party's right of association.
Yes, Your Honor. And those cases that deal with that generally are where a state law has forced a party to have an open primary. And then what you have is basically an attempted hostile takeover of a party's primary. The party's forced to hold a primary where anybody that has chosen to participate can vote, and then you end up in a situation a Republican open primary where you have a lot of Democrats joining to try to basically throw the election to the candidate they would prefer. The Supreme Court has said states cannot force a party to hold open primaries because then they're forcing that party to associate with people they do not want to associate with. The reasonable regulation here to host a caucus and then elect delegates whose term starts the next day prevents a situation of a hostile or cheating takeover at a caucus. It allows time to play out for the delegates' term to start the next day. It treats everybody the same, and it forces the Libertarian Party to associate with, they're not being forced to associate with anybody that they don't want to associate with. It's regulating how parties hold primaries and conventions. That is a simple, reasonable, very commonplace regulation that does not treat anybody differently.
What is the standard that I look at engaging or comparing the state's interests as you laid them out and the petitioner's interests?
Yes, Your Honor. The courts evaluate challenges to election laws using the framework, the Anderson verdict framework. The Anderson verdict framework recognizes that substantial regulation of elections, if they are to be, quote, fair and honest and have some sort of order rather than chaos, is to accompany the democratic processes. That's Anderson 460 U.S. at 788, Your Honor. The Anderson verdict framework recognizes that rules regulating how primaries and conventions are organized, requiring them to be organized, goes to the state's interest in having an organized representative party. And so what the standard does is the rigorousness, and actually the Iowa Supreme Court has adopted this in LULAC v. Pate in 2020. It has said that the rigorousness of the analysis is on a spectrum. Strict scrutiny, the most rigorous test, would be for laws that create severe restrictions on the right to vote. But where the challenge law, quote, only imposes reasonable, non-discriminatory restrictions that impact voting, we apply a deferential standard of review. That's precisely what you have here, Your Honor.
Is that any different than what could be referred to as a rational basis test?
No, Your Honor.
Okay. So it is different than when you say a deferential
sorry, it would not be any different. Here, in the rational basis here, the state's legitimate interest, again, is in openness and transparency of elections to ensure there's an audit trail. It's, excuse me, sorry. And it's to prevent overlapping delegate terms. It's to prevent dueling certificates. The state has multiple very legitimate interests here that we have discussed in our briefing. That's all that we have to show. We've made that showing. I'd like to talk about one more point about standing, or what the petitioners are calling standing. Your Honor was right to point out that standing might not be the correct term. It's really just whether the objectors here have a statutory right to make this objection. 43.24(1)A says the only requirement for an objector to bring a challenge is that they have the right to vote for that office. Here they do. The panel's decision found that they did. This is a 17A challenge that the petitioners are bringing, and they don't raise any substantial evidence challenge to that. The panel's factual finding about the objectors having, residing within the congressional district and being able to vote for these respective candidates. So standing, the jurisdictional standing, the court-created doctrine of standing has no place here in construing whether the objectors could have brought this challenge. The objectors are not the plaintiffs here. Petitioners are. Another argument, Your Honor, I'd like to discuss is that the injunction here does not run against the Secretary of State. The petitioners have sued the wrong party. An injunction against the panel does not give petitioners the relief they ask for, which is to enjoin certification of the names for the ballots. That's what the Secretary of State does. In any event, Your Honor, if there is to be an injunction granted against the panel, we would ask that Your Honor's order clarify the injunction should not apply to the 2024 general election ballot entirely. Here, the injunction should only apply to Secretary of State's certification of the 3 congressional races being challenged here. The Secretary of State needs to certify the names of all the other races in the state that are not being challenged here. The Libertarian Party and the petitioners here have not shown any evidence, nor could they, that they would be injured by a certification of the other unchallenged races. So we would ask Your Honor that if there is to be an injunction, to please clarify that it applies only to certification of these 3 congressional races being challenged here. And unless Your Honor has any further questions, I will hand this over.
Thank you, Your Honor. I'll endeavor to not repeat things that Mr. Valencia said. I do want to point out that the complaint raised by counsel about the timing of the hearing before the objections panel, they made no complaint before the panel about the timing of the hearing, and they have not raised that issue in any of their papers. They have not briefed that issue, and so that claim is certainly waived for purposes of today. In any event, the statutory deadline to file an objection was August 29th. And so nothing that the objectors did caused undue delay in this matter. As we explained in our brief, the purpose of Chapter 43 is to regulate the contents of the general election ballot through a primary process by political parties, or if they do not have a candidate who files for the primary, through the possibility of a special nominating convention. The state's interest in regularity in how the general election ballot is formed and who may be on it should be obvious. No candidate has an unfettered right to access to the general election ballot. To get on the general election ballot, a candidate has to follow certain rules. And if that candidate wants to get on the ballot by being nominated by his or her party, that party has to follow rules in order to have access to the ballot. I think the weakness of the candidate's constitutional claims is best explained by considering the hypothetical of what would have happened if those candidates had sued on the front end, if you will. If they had filed a lawsuit, say against the Secretary of State, saying we want to be excused from compliance with having county conventions, as the law requires, and filing lists of our delegates with the county auditor, as the law requires, because these requirements violate our right of free association. I think any fair reading of the Anderson-Burdick line of cases would show that that lawsuit would have been frivolous on its face. That these are the kind of neutral, non-discriminatory rules that apply to all candidates and are easily complied with. The Libertarians have never suggested, they've never shown, that somehow it was impossible for them to comply with their obligations to do basic party organization tasks. They simply didn't do it. And as a result, they left themselves in a position where they were not legally organized in a way that the law requires all political parties to be. That regularity in the process is important for transparency, and when somebody tenders a certificate of nomination to the Secretary of State, that there can be some check and balance on that process to see that the certificate is what it purports to be. The panel's role is, as is expressly set forth in the code, to test the legal sufficiency of a certificate of nomination. And when a party has not organized in the way that it is supposed to, it cannot produce a valid certificate of nomination to get access to the ballot. That is the state's interest, and that is why the panel correctly struck these candidates from the general election ballot. On the standing question of the objectors, I think nothing more needs to be said than a reference to the Iowa Supreme Court's decision in the Dickey case. Standing before an administrative agency or some state executive official is different in standing before a court. The objectors are not plaintiffs in this lawsuit. They have not invoked the judicial power to get a remedy against some defendant. They complained, as was their right under the statute, as people who can participate in the general election this November, that certain people who claim to have access to the ballot should not be there. That was their right under Section 43.24. And the standing cases cited by the candidates exclusively deal with the ability of a person to come to court and invoke judicial power to get remedy for some grievance. That's not what happened here. So the standing argument is completely misplaced. With that, Your Honor, I'd be happy to answer any questions that the court might have. Other than that, we would stand on our briefs. I would note, because it was raised by counsel, we did file as an attachment the voter registration information for the objectors. To the extent that that is an issue, counsel's statement was not accurate, but that is in the record.
And just so I'm clear, I haven't memorized the record, obviously. The panel did find, as a matter of fact, that the objectors were properly before the panel as objectors. Is that right?
Yes, and that is reflected in the written decision.
Commissioner Dunsey, you concur in that?
Yes, Your Honor.
Thank you.
Thank you.
I'll just keep going down the road. I just want to switch it up.
Thank you, Judge. What we're hearing from the respondents today is entirely speculative and entirely attenuated. Again, we have no injury in fact. The state has not been injured. What's happening here is there is a limit on the way that we enforce these statutes here, and what we're dealing with here today is discriminatory enforcement. It's created this chaos that these respondents are complaining of today. It's creating ballot chaos. It's creating chaos for our auditors. There was knowledge of this discrepancy June the 5th. It was not brought to the attention of the Secretary of State. I would posit that it's specious to try and separate the Secretary of State in this panel from the individual who is the Secretary of State who's responsible for noticing candidates and political parties that there's challenges with their convention and caucus processes under 39A.6. So what we're dealing with here, Judge, again, is we're not dealing with technicalities. We're dealing with people's right to vote. We're dealing with citizens of Iowa's right to have their candidates on the ballot. And there's no state injury here, whether it's an injury in fact or whether it's a hypothetical injury, that justifies taking away people's rights to nominate candidates and certify them to be on the general election ballot. So we would say that 181 minutes is absolutely a technicality. We'd also point to the court that the hypothetical, speculative, and attenuated arguments being made here by respondents are not actually factually relevant to this discussion. There's no threat of overlapping terms of delegates because this is the very first time that the Libertarians have been able to hold this convention as a major political party who got 2% of the vote in Iowa. It's not an issue.
Abstract.
Yes.
Do you not concede that that would be a legitimate interest?
I would.
3 years from now, or 2 years from now, whenever you have your next convention?
Well, I would hope that we will not be here in 2 years or 4 years from now, and that we would have a ruling that would give us the peace of mind to move forward with confidence in our nominating process, Judge.
Well, let's assume without tipping my hand that the process gets upheld. The interest of overlapping delegates, because there's a day overlap, would be a legitimate interest for the state to preserve the ability of people to be assured in the electoral process, would it not?
Well, Judge, that's actually addressed in the Libertarian Party bylaws. The way that they manage their delegates is actually governed in their bylaws, and there's no mention of the county auditors in those bylaws. They certify their delegates, And certainly there is a requirement that is in the statutes that should be followed, that those individuals be certified. But again, interveners knew as of June 6th that those delegates had not been certified to the county auditors. At that point, there could have been notification to the Secretary of State that this needed to be cured. At that point, Judge, the deadline for conventions had not yet passed. The deadline didn't pass until June 14th. So when we talk about compliance with a statute versus voting rights and suppression of voting rights, these folks held their powder. And they did it because they wanted to suppress Libertarians' ability to be on the ballot.
Well, whatever the motive may be, I'm not going to necessarily accept your point. Just regardless, you're not claiming that 39A is the exclusive process to address issues regarding the sufficiency of the nominating process.
Absolutely not, Judge. I'm saying that 43.24 is not the vehicle. 43.24 is very clearly the vehicle for addressing issues with a petition, issues with certification. It cannot be expanded, blown open to encompass the entirety of enforcement of Chapter 43. So,
well, to address Mr. Johnston's argument then, the way I heard it, is that the process manifests itself in the petition so that any flaw in the process is represented could be represented by a challenge to the petition, triggering 43.24.
and I think that that's fairly attenuated, Judge, and that's really the issue that I have with Mr. Ostergren's argument here. We have a statutory scheme that has been overhauled. It has been reviewed. The result of that statutory scheme being overhauled and the legislative intent that we saw was to narrow the purview of 43.24. It very specifically narrowed the purview of what objections shall be upheld to 43.15 and .18, if I'm 14 and 18, pardon me. So we are in a position where the state has already shown us through the legislature that they're looking at a more narrow view. To then expand that view by accepting the arguments of the interveners goes against the legislative intent that we have very clear evidence of. And I would say, Judge, if there were going to be an alternate opportunity for interveners or other like-minded people to get in court, they could always just file an injunction. They could file for injunctive relief saying that the county and the caucus processes had not been complied with. And then the relief would be commensurate with the harm. The Libertarians at that point would be ordered to either fix it or do it again. And if it had been, those objections had been brought timely, I'm sure that that's what we would be seeing now instead of this 11th hour attempt at voter suppression. I would, sorry, go ahead. Did you have another question?
I do have a question. I'm sure it's in the filings, in the papers on both sides of the file. Specifically, what was the extent of the overhaul that you referenced 3 years ago and how it relates to either 39A or 43.24?
All right. So, Judge, you asked me a question that is somewhat outside my purview, but I can point you to the two different statutes that appear in the code right now. Specifically, 43.24 was narrowed, and the language there was kept the same, except that there was a mandatory clause added. So the language of the statute says that objections to the legal sufficiency of a nominating petition or certificate of nomination filed or issued under this chapter or to the eligibility of a candidate may be filed in writing by any person who would have the right to vote for the candidate in question, vote for the office in question. And then the next, so this is the way the statute has been established. Fairly broad, I think we can all agree. And then it's narrowed to say objections relating to incorrect or incomplete information for information that is required under section 43.14 or 43.18 shall be sustained. And so the greater statutory scheme, Judge, I apologize, we'll have to get a better historian of legislative code for that, probably Mr. Hurd. If you would like him to speak on that, I would give my time to him.
Well, I just want to make sure I'm clear. You're saying that somehow the statutory scheme was changed in a manner that is beneficial to your argument that 4324 is not the appropriate vehicle to pursue redress.
That's correct, Judge.
And is Mr. Hurd the person he to pose that question to?
Well, I believe so, given his history, but I don't want to put him on the spot. So
Well, I will.
that's something that we can certainly brief for you as well, if he's not the one.
Mr. Hurd, go ahead.
Yes, and can you restate the question just so I know specifically?
I will try.
All right.
Mr. Cook has mentioned a couple times in her argument that the scheme for regulation of the electoral process was overhauled within the last 3 years. And what I'm trying to get to is, how was it overhauled in a manner that affects your argument that 4324 is no longer the means to challenge to make the challenge at issue here relative to the timing of the party process?
Yes, of course, Your Honor. So the overhaul was done in 2021 Act, Senate File 568, Iowa Acts, Chapter 147. Section 9 of that bill amended 43.24, subsection 1, to add the following sentence. Objections relating to incorrect or incomplete information or information that is required under 4314 or 4318 shall be sustained. So that is, the addition of that sentence means that the legislature is targeting specifically information contained within anything required to be filed under 4314 or 18. And if the court will entertain it, if you go to 4318, get it up myself, there is language in there that states that it is limited to the primary. Give me 1 minute. Yes, so in Iowa Code Section 4314, subsection 1, paragraph F, one of the pieces of information that is required to be filed is the date of the primary election for which the candidate is nominated. Therefore, that points to the legislature only wanting to look at primary elections and primary ballots. That additional code section, narrowing down specifically 4314 and 18, means that the legislature wants Iowa Code Section 43.24, objections to nominations, to be limited to that primary election. Which goes hand in hand with the right to vote language, also contained within 4324. Everyone has a right to vote for someone in a general election. It's only the primary election where you're limited to a party, where you have to have the right to vote for someone. And that indicates to the petitioners and to council that 4324 is supposed to be limited to primaries and not a wide open invitation for challenging elections or challenging nominations on a general election ballot.
So I'm not sure I'm clear on the interplay between the previous language in 43.24A and the added language in the amendment, and how it changes anything regarding the validity of the process used by the objectors in this instance.
Thank you, Judge. Because 43.14 and 43.18 are limited to the contents of the nominating petitions, we think that that is the legislature telling us that the concerns that are had here, that the objectors are bringing, that the legal sufficiency is not met because of process. We believe that that's an overreach that's, in our view, is supported by this narrowing of this particular section and its consequent narrowing of the authority of the panel under Chapter 43. There wasn't anything to specifically narrow the purview of the panel, although we would argue that historically, particularly in the Schmidt case, which dealt with the candidacy of U.S. Senate candidate Abby Finkenauer, there's a narrowing that is very specific to petitions and certificates where you're looking at the actual content. You're not looking at the process that was created that generated those petitions and that certificate. And we will also add that the Schmidt decision dealt with Ms. Finkenauer's campaign during her primary and not for the general election. So when we're looking at this particular section, there's all kinds of ways that we can show that the panel is limited in its authority. And this expansion of authority of this panel, when we already have perfectly good remedies, you can file an application for an injunction to the court and have a neutral hear you. One of the issues that we've had with this case and with the body of precedent that comes out of the panel is this constant politician electioneering over who has the right to sit on the panel. Every panel decision you're going to read is going to start with somebody trying to get somebody else booted off the panel based on their politics. So if we make the panel the remedy, we increase that problem. We already have a remedy. It's filing for an injunction under the Iowa Rules of Civil Procedure. So, and then you go to a neutral, you go to a judge. So opening this for governance by partisan politics, I think that you would see the statutory scheme and the burden on our courts explode. We don't support that kind of partisan electioneering here in Iowa.
So going back to the amendment, if the second sentence to 43.24a that was added relates to the content, what else remains in the first sentence to be dealt with when dealing with the legal sufficiency if content is already addressed in the second sentence? Is it processed by default, all that's left to be dealt with in the first sentence?
No, Judge. I would say that what it's doing is it's narrowing the focus to the content, not to the process. So I would argue that the way that the legislature chose to narrow 43.24 was to make sure that our concerns are with the four corners of the paper and what it contains.
So what remains as far as the effect in the first sentence? What's meant by legal sufficiency?
Well, I would say, Judge, first of all, this is a permissive standard. Objections may be brought, not objections shall be brought. So when we talk about legal sufficiency of a nominating petition, there's a whole list in 43.14 and .18 about what's required for you to get support. Again, in a primary, to get on the ballot, you have to have these signatures. And I would add as well, Judge, that I wanted to clarify for the court the purpose of Chapter 43. The purpose of Chapter 43 is not to police the ballot, and it's not to police caucuses, and it's not to police conventions. Chapter 43.1 specifically states, the purpose of the chapter is created to create guidelines for, quote, election by the members of various political parties for the purpose of placing in nomination candidates for public office. The point of the statute is to get people on the ballot, not to keep them off the ballot. And that's straight from the legislature. So substantial compliance here, which, as a sidebar, we have not waived substantial compliance as a legal issue. Legal facts that have not been argued, obviously, before the panel are not an issue here. We would point the court to facts that the respondents have raised, songs they did not sing previously. We were told that there wasn't a convention, and then we were told that the convention wasn't handled properly. So the Libertarian Party has been on the back foot in terms of receiving multiple different bases for the supposed state interest here. I might add that election integrity, I don't believe, was argued before the panel either. And how this impacts our election integrity, the state has yet to show us. But here, I think we go back to substantial compliance, Judge. And in Burnham v. City of West Des Moines, which is 568 Northwest 2nd, 808, Iowa, 1997, substantial compliance exists when the action taken, although not literally satisfying the statutory requirement, nevertheless fulfills the minimum objectives of the statute. We've acknowledged that proceeding to convention from caucus before 181 minutes have passed did not literally satisfy the statutory requirement, yet the caucus and convention processes fulfilled these minimal objectives of Chapter 43. Substantial compliance here weighs with giving voters the opportunity to choose which candidates will be listed on the ballot in an election against the obligations of the candidates to meet the requirements of the nomination process, including providing eligible electors with enough information to make an informed decision whether to sign a nominating petition. So, again, we're dealing with application of this particular statute to a political process that is not entirely designed to address. We're talking about primaries when we talk about Chapter 43. But here, we're not talking about a primary. We're talking about a caucus and then nominations for the general election, which is just one more reason that to hang our hats here on Chapter 43 as the mechanism for policing the Libertarian caucus and convention process doesn't actually make factual sense, and it's certainly not supported in the statute.
Mr. Hurd, anything else?
Yes, Your Honor. If I could back up to try to get an answer to your question on what's remaining in the sufficiency argument, and that would be 43.15, the signatures required for a petition, nomination via petition, specifically that one, and then also 43.17, whereas if the candidate is already nominated through a nonpartisan manner, they're precluded from being nominated in a partisan manner. So that would be two grounds by which 4324 cover that are not in that new sentence that was added by the legislature in 2021. And then the example or the attachment that the respondents or the objection panel attached to, I believe it was their brief, most recent brief, it covered a situation on a general election. We'll agree, but that was under Chapter 45 of the Iowa Code, not Chapter 43 of the Iowa Code. Actually, 44, Chapter 44, not 45, Your Honor. And if you look specifically at Iowa Code Section 4324, the objection panel is limited, in this circumstance, objections are limited to filings made under this chapter, Chapter 43, not 44 or 45. For that example of a general election objection panel decision, not relevant for this matter. And I would just like to briefly touch upon the substantive due process argument on behalf of the petitioners and what the state is arguing. They're arguing that the interest of the state is limited, or they only have to prove that they have an interest in regulating the timing of caucuses and conventions and the reporting of the county or the caucus delegates to the county auditor. There's a lot more that the state has to justify than just that. They have to justify using the non-compliance of those statutes to removing a candidate from a ballot. It is the removal from the ballot that is at issue, not the timing or reporting requirements that the state believes that's interested in. And since it is the removal of the ballot, of candidates from the ballots at issue, I believe strict scrutiny or the heightened standard is the appropriate standard on that analysis.
Because of the severity of the result?
Yes, yes.
But isn't it the severity of the burden that I look to?
I would say the burden is the same as the result. The result results in the burden.
Well, here we're talking about a burden of 181 minutes for your own admission, as compared to the removal of a candidate. The burden would seem relatively slight in relation to the overall process.
Yeah, sure.
Well, Judge, I think you just pointed out one of the issues that we have here. The candidates for the Libertarian Party are not the ones bearing the burden of the sufficiency of the caucus and convention processes. And so when we look at a burden shifting analysis, again, that's directed at the party, not these individual candidates. To have them bear the burden of sufficiency of caucus and convention proceedings in order to stay on the ballot when their nominating petitions are in and approved, there's absolutely no objection to any of the fundamental filings that candidates need to do to get on the ballot in Iowa as it relates to any of these candidates. So to place the burden on them of having the proper proceedings at their party's convention, I think that far outweighs the state's interest in election integrity. We can't put that burden on candidates. And I would also say, Judge, that when we talk about burdens, I'm concerned about the lifting of the injunction as requested by Mr. Valencia. What I'm mainly concerned about is the negative impact to our county auditors by doing this certification piecemeal. We don't have any objection that the ballots for Iowa Congressional District 2, where there's no Libertarian candidate, those should be certified. Absolutely allow those auditors to move forward with the printing and coding and all of the other processes that are integral to fair and, frankly, clean elections in Iowa. But we don't know if certifying the ballot piecemeal and holding just these candidates for Congress off the ballot will actually create a greater problem for our auditors. We know that it can make ballot printing challenging because you have to have the spacing right for all the different names on the lines. There's issues with setting and resetting the machines and doing the coding. I would just offer that I think we need some input from our county auditors, and particularly our smaller county auditors, to whether lifting the injunction and directing them to begin this process piecemeal would be helpful, or if it would in fact be hurtful. So I think that, when we talk about what our auditors need to be dealing with here, they're dealing with a delay. There's no way around that. It's been occasioned by Secretary Pate delaying the hearing until 3 weeks before the election, and Mr. Ostergen failing to file his objections for over 2 months following his inquiries to the auditors. So I just want to make sure that we're centering the auditors and their needs in this process so that we have elections we can rely on.
Not sure I understand. If I, as I will, rule quickly on the merits of this challenge, up or down, what remains to be enjoined? If I find for the petitioners, you're on the ballot. If I find against the petitioners, you're off the ballot. And we've got a timeline to follow here. I'm not following why the injunction needs to be in place once I have dealt with the merits and addressed the main issue as to why the injunction was filed, because of some likelihood of success on the merits.
The reason is, Judge, is because respondents have already filed an application for interlocutory appeal, and as you know, that doesn't come with a stay. So we would like the injunction to continue until the interlocutory appeal is heard, because unfortunately, your decision today, we already know because the interlocutory appeal application is on file. We still have some more hoops to jump through here.
Okay. All right. Anything else from the petitioner side?
No, thank you, Judge.
Mr. Valencia.
Thank you, Your Honor. I'll start with the 39A discussion that was just had. If we look at the 39A statute, the provision they point to, it says if the state commissioner or county commissioner becomes aware of an apparent technical violation, the state commissioner or county commissioner may administratively provide a written notice and letter of instruction. It doesn't authorize the panel to do anything, and it's a permissive statute. It doesn't require written notice for technical violations. It allows the commissioner to give that, but it is strictly permissive. 39A existed in 2020, and then in 2021, the legislature added this sentence that we detail what the old 4324 looked like at our brief in pages 11 to 13, and then we note that what was added, which is the second sentence that was discussed. The second sentence, though, relates to 43.14 and 43.18, which is strictly just about the nomination papers, primary nomination papers. So that includes a petition for nomination and an affidavit of candidacy that goes with that. The second sentence says nothing about a certificate of nomination or, more generally, a candidate's eligibility. We can only speculate why that second sentence was added, Your Honor, and that's sort of what has been going on here. If we were to speculate, you could look at the history of the objections panels and what was going on. There were objections made to nomination petitions for signature deficiencies, missing dates, things like that. The state objections panel applied either substantial compliance or a very, very deferential standard and said, that's okay, we're going to let those go by. And the legislature said, those signatures on nomination petitions, those are requirements that shall be sustained. So the legislature stepped in and said, the state objections panel needs to not let those go by. It didn't say anything about the objections panel's authority to hear objections about certificates of nomination. 4314 and 4318 have nothing to do with certificates of nominations, and they couldn't because those two provisions deal with nomination papers. A certificate of nomination is certifying somebody that's already been nominated. They've completed the nomination papers process, and it's now proceeded through to them actually receiving the nomination, and now it must be certified. The objections panel sits there to hear objections to certifications of nominations. If Your Honor were to take their point of view, it would delete out certificate of nomination from the first sentence of 4324. There would then be no way to challenge under 4324 certifications. And that's just not what the text says. We give effect to every provision in an Iowa law, and the petitioners would have to delete that out of the law. As for Schmidt, the 2022 case that petitioners mentioned, that dealt with a nomination petition and a 4315 challenge to that nomination petition. It did not, and it was signatures, Your Honor, and so the Supreme Court's decision there was limited to what objectors can challenge as to signatures on a nomination petition. That's what the opinion says. That's what the Supreme Court applied there. 4324-1A still survives to allow the panel to hear objections to a certificate of nomination. Effectively, what the petitioners are doing, Your Honor, is putting an only in front of the second sentence that was added. They would have it read only objections relating to incorrect or incomplete information that is required under section 4314 or 4318 shall be sustained, but the statute does not say only those shall be sustained. It is a clarification by the legislature panel to not let those go by. They had no discretion on those. As for the argument that 4324 challenges are only allowed for the four corners of the certificate itself, Your Honor, that's not in the text. It's the legal sufficiency, as Your Honor has well pointed out. Legal sufficiency of the certificate of nomination is what objections can be made for. And here, the objector said this certificate was legally insufficient because the person who issued the certificate had no authority to issue it. But even if Your Honor were to just decide that it was only the four corners that you could look at, if you look at the four corners of the certificate of nomination, it says that we, the chairperson and secretary of the convention, certify that at a convention called by the chairperson of the party, quote, and this is the important part, all of the appropriate delegates or committee people met and selected the candidate. There were not appropriate delegates or committee people here that selected this candidate. There were no valid candidate delegates because there was no valid county convention. As for substantial compliance, Your Honor, non-compliance is not substantial compliance. It's not as if some of their delegates were valid and some were not, and they forfeited this issue anyways. They raised it in their reply they filed today at 12:15, but they did not raise it before then. We acknowledged that in our initial response brief that we filed on Tuesday, and they did not raise substantial compliance after that until today at 12:15. As for the First Amendment analysis, Your Honor, you were correct to point out that the burden, what you analyze is the burden and not the result. And the burden here was a very reasonable, non-discriminatory burden to hold your conventions at least a day after your caucuses. And for all the state interests that we've highlighted, not having competing delegates, open and transparent elections, that's what that is there for. Just because the Libertarian Party's bylaws may address one of those interests does not matter. There's no exception in the statute for if the bylaws address the state's compelling interest. The analysis is to look at the statute and see if it pursues a state interest, and here it does. And Your Honor, I would again request that any relief going forward, as you pointed out, should be limited to just the 3 congressional races challenged here. The interlocutory appeal would not exist if there's a final decision. Then we have an appeal as of right if it goes against us, or they would too. So I don't think the interlocutory appeal should affect how it affects the rest of the certifications. The Secretary of State needs to certify the names for nominees for all the unchallenged races in Iowa. If Your Honor has no further questions, I will let Mr. Osterman speak.
Mr. Osterman.
It is a deeply held tradition of lawyers to try and get the last word, Your Honor, but I will simply say if you have any questions, I'd be happy to answer. If not, I will yield the floor.
I do not. Thank you.
Thank you.
I might give the petitioners the last word. Anything else you want to fold in that we haven't talked about?
Not that we haven't already talked about, Judge. If there's anything Mr. Hearn has, though.
I do have a question, but just Lindsay's argument caused me to focus on the language in 4324, the first sentence. And what we haven't talked about is the language that pertains to objections to the eligibility of the candidate. Why wouldn't the eligibility of the candidate be the grounds under which these challenges are properly made, because the candidates aren't eligible if they haven't followed the statutory process?
Judge, I'll ask your permission to take a look at the text of the statute to respond fully.
Your Honor, the language in 2324 subsection 1, paragraph A, where it states the eligibility of a candidate, objections to the eligibility of a candidate may be filed in writing by any person. The eligibility relates to an overall general eligibility, whether they're the right age, whether they are a resident of their district for certain races, such as the General Assembly, and whether they are a citizen. Questions of that nature, not the technical party business eligibility criteria. There's nothing that states in there that the fact that the party did not strictly comply with a code section automatically means that a candidate is no longer eligible. Their eligibility relates to the candidate specifically, not the nature or the business of the party in nominating that candidate.
Is eligibility a defined term under the statute?
I don't believe so, Your Honor.
Is there a separate provision that outlines what eligibility refers to?
Not that I'm aware of, Your Honor.
So what is the basis for your argument that eligibility only goes to things like residency, citizenship, etc.?
Because the specific technical objections are already stated in the new sentence, where it's relating to the certificates of nomination or the petition. Those eligibility would be to the exclusion of all the specific filings that are required under Chapter 43, which do not address the age of the candidate, the citizenship of the candidate, the residency of the candidate. That's where I get that argument from, Your Honor. She may answer as well, Your Honor.
Thank you, Judge. The Constitution of the state of Iowa defines eligibility, Judge, and that would be the definition that we would rely on here. I would also like to point out that respondents are addressing the eligibility of delegates, not candidates, whereas the statute is specifically focused on whether the candidates have met the eligibility requirements.
All right. I got a good grasp of where you're all at on your positions. I will take this matter under advisement. I know that this is a time-sensitive topic, which is going to be clear violence. I will endeavor to get a ruling out that addresses all of these issues in relatively short order. and perhaps get the matter en route to where it's probably going to be ultimately decided. And I will do my best to get my part of the process done in a way that legitimately addresses the issues both sides have so zealously presented to me today. And with that, we are here. Thank you all.
Thank you.
Video of people leaving.
Get 6 times longer lasting freshness plus odor protection with Downy Unstoppables. Try for under $5.
Downy Free and Gentle. Softer clothes for skin's sake.